So, I can see that we already have quite a number of participants on the call. And I would suggest for us to just start, and we'll make sure to admit the other persons as they join the session today. So, hello everyone. I am Sheila Schweighofer, and I'm one of the directors at Africa in the Moot. Together with my co-moderator, Ghada Erfoui from Africa in the Moot's Educational Program Committee, and on behalf of Africa in the Moot, I'd like to welcome everyone to Africans in the Moot's first training series in the context of this year's Moot problem. So Africa in the Moot is an initiative which was founded with the aim to support students from Africa universities to participate in arbitration moot courts, in particular the Moot, in order to promote a greater representation of African students in such competition. And one of our key objectives in doing so is to support access to the best training sessions given by reputable practitioners and in the field of international arbitration. So in this context, it's in this context that we launched already last year, actually our training series, and would like to thank Africa in the Moot's Educational Program Committee for preparing and setting up such an impressive program for this year. We're kicking off this year's series with an exceptional guest, Professor Gary Bourne, who needs no introduction, as you're certainly already quoting his publications in your claimant's memorandum to justify whether or not there is a valid arbitration agreement in this year's Moot problem. Nonetheless, I will hand over to my co-moderator Ghada for an introduction of Professor Bourne before we dive into his lecture on arbitration agreements. Please take note that today's session is recorded, and also please make sure to mute yourselves. A PowerPoint presentation will be made available at a later stage of today's lecture. So thank you, everybody. Enjoy the session. And now, Ghada, on to you.
Thank you, Sheila. My name is Ghada, and it is my honor today to introduce our guest, Professor Gary Bourne, Chair of the International Arbitration Practice Group at WilmerHale, and the world's preeminent authority on international commercial arbitration. Professor Bourne has served as counsel and has sat as an arbitrator in over 1,000 arbitrations. He has published a number of leading works on international arbitration, but he is perhaps best known for his treatise, International Commercial Arbitration, the leading treatise in this field. Among many accolades, Professor Bourne was recognized for his outstanding contribution to the legal profession, being, and I quote, in a class of his own and revered around the world for his work on international commercial and investment arbitration. This is the second year where Professor Bourne contributes to our lecture series, for which we are very grateful. And for that, we would like to thank him and WilmerHale for the constant support to the Africa in the Moot initiative. Before handing over the floor to Professor Bourne, I would like to kindly remind the participants to mute themselves and drop their questions in the chat box. And without further ado, Professor Bourne, the floor is yours.
Thank you so much, Ghada, for that kind introduction, and Sheila as well for moderating this session, and of course thanks to Africa in the Moot for such a noble enterprise that is, I think, so important in the education of young arbitration practitioners. Perhaps most of all, of course, though, thanks to all of those who choose to spend their Saturday morning or afternoon, depending on where you are, listening to me instead of enjoying the weather in the autumn or wherever you may be. The topic today is international arbitration agreements. We could spend the entire weekend, you'll be glad we're not, but we could spend the entire weekend talking about international arbitration agreements. And I think today I can only highlight some of the principal themes, the main issues that arise out of international arbitration agreements for you to keep in mind, both for the Moot problem, but inevitably, I can assure you, the rest of your careers. I think it's not just Moot problems that present questions about international arbitration agreements. It's, I think, almost every arbitration that I've ever participated in, all 1,000 or 1,100 or however many there may be. And so knowing what issues to spot, knowing how to go about addressing those issues is of critical importance. One of the reasons, of course, that those issues are of critical importance is because, like many types of arbitration, you don't have an international arbitration, either an international commercial arbitration or an international investment arbitration, without an international arbitration agreement. Consent to arbitrate is, as every textbook tells us, the foundation of arbitration. Without a valid arbitration agreement, arbitrators aren't really arbitrators. Without a valid arbitration agreement, parties can't be compelled to arbitrate, and the awards that those guys, girls make in the putative arbitration won't be recognized and enforced. And it's therefore essential to determine whether or not an arbitration agreement exists, what kinds of challenges can be made to it, and what that arbitration agreement provides, both in terms of scope and procedures. It's not just that arbitration is the foundation and prerequisite for an international arbitration. The arbitration agreement also defines what the arbitration will be like. Arbitrations are like people or snowflakes. Everyone is different and unique in many ways, because most arbitration agreements also are unique and different from others. You can have agreements to arbitrate everywhere from Albania to Zimbabwe. Every conceivable arbitral seat, you can equally have arbitration agreements in every conceivable language, from Albanian to Zulu to what have you. You can have arbitration agreements in front of one arbitrator, or, as the ancient Greeks did, 301 arbitrators. I wouldn't recommend that particularly. You can have arbitrations that are ad hoc and arbitrations that are institutional, and all of it depends, obviously, of course, on the parties' agreement, the parties' arbitration agreement, which can provide for one type of arbitration, or alternatively for a radically different type of arbitration. And that's one of the reasons, another one of the reasons that we spend so much time examining international arbitration agreements. How the first volume in my 3-volume treatise on international commercial arbitration is devoted entirely to international arbitration agreements. We can see the foundation, the textual, the doctrinal foundation for those propositions in both the New York Convention, Article 2, which you're familiar with, Article 2.1 and 2.3 in particular, as well as the UNCITRAL model law, Articles 7 and 8. Those various provisions refer to both that creature that we're studying, the arbitration agreement, and also to a number of important aspects concerning that arbitration agreement, that creature. Importantly, both Article 2 and Article 8 of the model law, Article 2 of the Convention and Article 8 of the model law, provide for the presumptive validity and also specific enforceability of the arbitration agreement. Contracting states to the New York Convention are required by Article 2.1 of the Convention to recognize international arbitration agreements, give effect to them, subject to only narrow limitations. And Article 2.3 requires courts of contracting states to refer parties to arbitration if there is a valid arbitration agreement, again, subject to only narrow limitations. National courts have interpreted those limitations to include only the generally applicable contract law defenses, things like fraud, mistake, lack of consent, frustration, impossibility, that would apply to other types of contracts. And Article 8 of the Procedural model law gives effect to exactly the same obligations that the convention imposes. Let's talk a little bit more about what this creature, the International Arbitration Agreement, looks like, what it does, what it should say, and also perhaps what it shouldn't say, how you shouldn't draft it. The arbitration agreement, of course, as we know, is separable, or sometimes referred to as either independent or autonomous. Even if the arbitration agreement is included as simply a clause in a larger commercial contract, the arbitration clause itself is a separable, autonomous agreement with its own independent existence. It may be a type of parasite relying on the underlying commercial contract for much of its relevance, but it remains an independent agreement, an independent contract, which has important consequences both for questions of formation, but also questions for validity and enforceability. And I'll say a few words about those consequences of the separability doctrine in a moment. The New York Convention and also the model law refer to two kinds of, in broad terms, two kinds of arbitration agreements. One, a standalone arbitration agreement, which self-evidently is an independent, autonomous creature. One encounters these types of standalone agreements, a contract that is nothing more than an agreement to arbitrate relatively infrequently. I don't believe that there are empirical studies of this, but my own experience suggests that well more than 95, probably closer to 99% of all international arbitration agreements are not so-called compromis or submission agreements. Those agreements apply to an existing dispute, a dispute that has already arisen in the past. And all these submission agreements, these arbitration agreements do, is refer that dispute to arbitration in a specific manner. Those agreements, those arbitration agreements, are literally pure arbitration agreements. They do nothing but refer an existing dispute to arbitration without being part of some broader commercial contract. The other 99%, or however many percent one wishes to postulate, of international arbitration agreements are different. They are arbitral clauses, in the words of the New York Convention, that are found within broader commercial contracts. You have a sale of goods contracts, an insurance policy, a joint venture agreement, and Article 21 within 50 or so other articles dealing with everything from price to delivery terms to notice provisions and the usual type of boilerplate that one finds in a commercial arbitration in a commercial contract. Clause 21 is the agreement to arbitrate. That agreement applies not to existing disputes, typically, the way we've seen with a compromis or submission agreement. Instead, it applies to future disputes. The business people, the business women who conclude that commercial contract hope there'll never be a dispute. They're in the happy honeymoon of having successfully negotiated a good commercial deal, and in a perfect world, and frankly, in a relatively normal world, because most contracts don't lead to disputes, no dispute will ever arise. And as a consequence, there'll never be anything that needs to be or is referred to arbitration. The arbitration clause within the broader contract is there in the event that future disputes do arise later after the contract's been concluded. And the arbitration agreement is a type of procedural contract that provides a mechanism for referring the parties dispute to arbitration. We're all familiar with what those clauses should look like. Those clauses, arbitration clauses in a contract, should look like the model clauses that most arbitral institutions recommend, whether the institution is the ICC, the London Court of International Arbitration, the Cairo Regional Center or some other arbitral institution. And we'll come in a few moments to what those clauses can and should ordinarily address and say. Before we do that, though, it's worth returning and underscoring one point that we've already touched on, which is the separability principle, the presumption of separability of the arbitration clause. Even though Article 21 is embedded within a broader contract, the arbitration clause itself remains separable. It remains an independent contract between the parties. And importantly, there are several consequences from the separability doctrine. One consequence is that the invalidity or illegality of the underlying contract, indeed, even the non-existence of the underlying commercial contract, does not necessarily or even ordinarily imply the invalidity, illegality, or even the non-existence of the arbitration agreement. The fact that the underlying contract has been terminated, the fact that the underlying contract is rendered impossible of performance or has been frustrated, and the fact that the underlying contract was procured by fraud, none of that means that the arbitration agreement also is invalid or unenforceable. And that's for the simple reason that the arbitration agreement is a separate contract. It is formed through the exchange of promises by each party to resolve their disputes by arbitration. It's not formed by virtue of the underlying commercial bargain between the parties, which is reflected in Articles 1 through 20 and 22 through 50. And as a consequence, the fact that the parties terminate their commercial contract does not mean that they've also terminated their arbitration clause, or that the frustration of the underlying contract also frustrates the arbitration agreement. To take an obvious example, the fact that sanctions forbid a party from delivering certain types of goods to its counterparty doesn't mean that the parties are also prevented from resolving their disputes by arbitration. Let's move, though, to the different kinds of international arbitration agreements, whether submission agreements on the one hand, compromis, or arbitral clauses in the underlying commercial contract, and consider what types of issues can arise, can be presented by those two different categories of arbitration agreements. The first and often most important issue that parties must address as they both draft and consider enforcing an arbitration agreement is whether it is an ad hoc agreement to arbitrate on the one hand, or alternatively an institutional arbitration agreement on the other hand. An ad hoc arbitration agreement is simply an agreement to arbitrate, not pursuant to any pre-existing set of rules that come with an appointing authority and administering institution to address the administrative and logistical aspects of the arbitration. An ad hoc arbitration agreement is simply a provision that says something like, all disputes relating to this contract shall be finally resolved by arbitration, period. That's an arbitration agreement. It refers a defined set of disputes with a particular scope, all disputes relating to this contract, to final resolution by a means of dispute resolution, arbitration. And that is independently sufficient to constitute, in almost all cases, a valid arbitration agreement. It is an ad hoc, what is called an ad hoc arbitration agreement. And that is referred to as well, specifically in the New York Convention, the possibility of both ad hoc and institutional arbitration agreements. And the arbitration is conducted not pursuant to some pre-existing set of procedural rules, but rather according to the parties' agreement to arbitrate. The parties' particular agreements about the procedures of the arbitration. And when the parties cannot agree to the arbitral tribunal's procedural discretion. There's no broader set of default procedural rules that might apply. Everything is left to the parties' procedural autonomy and the arbitral tribunal's procedural discretion. Importantly, there is no appointing authority in these types of arbitration, except for what is provided by the default provisions of national law in the arbitral seat, wherever the parties may agree that that is. If the parties cannot agree on the identity, the composition of the arbitral tribunal, the only place that they can turn is to the national courts in the arbitral seat, who are charged under the applicable national arbitration legislation, in the case of the UNCITRAL model law, Articles 10, 11, and following, with the selection and appointment of arbitrators. There's no arbitral institution to address such issues as challenges to the arbitrators, fixing the arbitrators' compensation, scrutinizing the arbitral tribunal's award for matters of form and the like, fixing the arbitrator's compensation at the end of the arbitration. None of that exists. And there's no default procedural rules to address the countless issues from confidentiality to consolidation and the like that can arise during the arbitral process. It's for that reason, because there is no administering authority, no appointing authority, and because there are no default rules that address many of the ordinary issues that can come up during the arbitral process, that most parties don't choose ad hoc arbitration. Instead, they choose institutional arbitration. And they choose that type of arbitration because it provides an appointing authority rather than national courts on the one hand, and because it has default procedural rules that answer a number of important questions that may arise, resolve important uncertainties that may arise during the course of the arbitral process. Perhaps the most important role that an arbitral institution plays is exactly that of an appointing authority. The parties are free under the New York Convention, most national laws, to agree upon the procedures for constituting the arbitral tribunal. Most procedures are familiar. Typically, the parties agree on the identity of a sole arbitrator if they're able to do so, or alternatively on a mechanism for choosing a three-person tribunal. Often, each party selects one co-arb, the two co-arbs together, or the parties select the presiding arbitrator. But while parties frequently can reach agreement on those particular issues, they also frequently are unable to do so, requiring a third party to select either a sole arbitrator or a presiding arbitrator. And it's there that arbitral institutions, whose principal function in life is to select international arbitrators, are thought, I think rightly, to perform better than national courts, who only occasionally need to do something quite different from resolving civil and criminal disputes, which they ordinarily do, namely choose an international arbitrator. And as a consequence, parties, commercial parties, very distinctly prefer institutional arbitration. If one is going to follow that line of thinking and agree to an institutional arbitration clause, then one needs obviously to choose an arbitral institution. Fortunately, there are many sterling choices available in today's world. One can choose, as I mentioned previously, the ICC, the International Chamber of Commerce, based in Paris, in business since 1920 or so, and still the world's preeminent international arbitration institution. But if one wishes something different, either in the common law world, London Court of International Arbitration, AAA or ICDR in the United States, the Singapore International Arbitration Center, there's a plethora of choices. Importantly, as one makes those choices, one is well advised to use the standard model clause that each of these institutions provides. You can find them on the respective institution's website. And one ought, although as young lawyers, perhaps one is tempted to improve on what one has inherited from earlier generations, one ought to tinker with these clauses only with great care. Any changes that one makes will be scrutinized for why why did the parties here depart from the recommended model clause? And the model clauses as well have been based on the accumulated experience of generations in many institutions of practitioners considering what sorts of problems can arise from different types of language in arbitration agreements, arbitration clauses. Once one has selected a particular institution and a particular model clause, one needs to address a number of important issues. And I have time today only to very quickly go through and in only a short compass each of these main issues. But it's essential to address the scope of the arbitration clause. It's essential to address the method of constituting the arbitral tribunal. It's essential, particularly essential, to address the arbitral seat. It's essential to address the language of the arbitration. And it is highly recommended to include a choice of law, choice of substantive law provision. Let me say a word about each one of these topics. Most institutional arbitration clauses have a broad scope. That means they extend to a wide range of disputes. Almost all arbitration agreements, at least the arbitral clauses as opposed to submission agreements, relate to disputes concerning a commercial contract, and specifically the commercial contract in which the arbitration agreement appears. Thus, one sees language such as all disputes relating to this contract, or alternatively, all disputes arising out of this contract, or differently, all disputes arising under this contract. National courts have struggled with the possible differences between these different formulations. Parties use different words, perhaps they meant different things. And in general have concluded that language such as relating to or in connection with is broader, more all-encompassing than arising under or arising out of. In general, commercial parties prefer a broader rather than a narrower scope of arbitration clause. They want to include non-contractual claims, whether for misrepresentation, breach of fiduciary duty, misappropriation of trade secrets, within the scope of their arbitration clause. And one enhances the likelihood of that happening by using the former type of language, all disputes relating to this contract, instead of the latter, all disputes arising under this contract, which arguably is limited to purely contractual claims. Many model institutional arbitration clauses already have a very broad scope within them. If you look at the standard clauses recommended by everyone from the Cairo Regional Center to the ICC to other institutions, both in Africa and elsewhere. And one therefore needn't tinker with that language, but particularly if such suggestions are made by a counterparty, or if one is in the ad hoc world, one needs to consider drafting the clause quite broadly to include as many disputes related to the parties' relationship as possible. Second, critically important is the seat of the arbitration. It's relatively easy to draft a clause addressing the question of the seat of the arbitration. One literally has to say something only like, the seat of this arbitration shall be Lagos, Nigeria. And one has accomplished that. Or alternatively, the place of arbitration shall be Cairo, Egypt. That is sufficient to select the arbitral seat. Note that in selecting the seat, or the synonymously place of arbitration, one isn't choosing the location, geographical, physical location where the hearings will be held or where the arbitrators must meet. That is a different issue. The seat or place of arbitration is the legal home, the domicile, so to speak, of the arbitration. And in a sense, a very accurate sense, it is a choice of law as opposed to a choice of venue or physical location. By choosing the seat or place of arbitration, one chooses the arbitration legislation that governs the arbitration itself, including, most importantly, the national courts to which one would go should some sort of intervention in the constitution of the tribunal or challenges to arbitrator be required from a court, and where an award made by the tribunal could be annulled or set aside. I'm not sure if there was a question just there. I'm happy, of course, if there are questions as I go along to address anything that might arise.
Thank you very much, Professor Bourne, for drawing the attention to the questions. I think that there is one question which is of relevance, and maybe I can put a bit more into context. The question is if there are any exceptions to the principle of separability. And I think that one aspect that might be interesting for the, especially the Moody's who are following us today, is in light of potential claims of corruption of a, so if we have a contract which is potentially tainted by corruption, or at least that there's a party which submits allegations of possible fraud in concluding the main agreement, would this, or how would this impact the arbitration agreement? How would a tribunal basically deal with this? I know that it's a hot topic, for example, in investment arbitrations, but I think it'll be more interesting to have an insight on how this would work in international commercial arbitrations. So we'll be very grateful for any input on that.
More than happy to address that. And as you rightly say, it's a hot topic. It's a hot topic in a sense, not just for Moody's this year, but it's one that has perennially risen and then re-arisen in both commercial and investment disputes. And there are two possible ways to address the question. One, because an underlying contract was procured by fraud, or alternatively corruption, a particular type of fraud, the underlying contract was void ab initio, and because if the parties had never concluded the underlying contract, they also never would have concluded the arbitration clause, which is part of that contract. There's no valid agreement to arbitrate. The nullity ab initio of the underlying contract necessarily entails the nullity of the arbitration agreement. The alternative view is the separability presumption that I've referred to previously. The arbitration agreement is a separable autonomous contract. The fact that the underlying contract was procured by fraud or its terms were affected by fraud doesn't entail the non-existence or invalidity of the arbitration clause that was included in that contract, because that arbitration clause is in fact a separable contract, and the non-existence or nullity of the underlying contract isn't something that can or does affect the arbitration agreement. National courts have addressed this issue, and a couple examples are worth mentioning. One, the well-known Fiona Trust case in the United Kingdom, where an underlying ship charter contract was procured by corruption. The company that was chartering the vessels, going to use the vessels, bribed an executive officer of the vessel owner in order to obtain grossly below market charter rates. And the fraud was discovered and said to entail the nullity of the underlying contract, as well as the nullity of the arbitration agreement. We never would have concluded the underlying contract had we known of such fraud. And equally, we never would have concluded the associated arbitration agreement had we known of such fraud. Ultimately, the UK Supreme Court, House of Lords, rejected that argument. It concluded that the arbitration agreement, which in that case was a standard institutional arbitration clause, indeed the type of clause that was characteristically, customarily used in these types of ship charter arrangements, was a separable contract and that it wasn't induced by the fraud in the underlying contract, that fraud was directed to the underlying contract, and that there was no fraud in relation to the agreement to arbitrate. There were no misrepresentations about the terms of the arbitration agreement. There were no misrepresentations about the agreement to arbitrate, and hence there was, even if there were claims that the underlying contract was procured by corruption and ultimately null and void, that didn't apply to the arbitration agreement. The same thing happened with respect to an arbitration agreement between a major multinational company and the Republic of the Philippines, where the allegations were that the underlying contract had been procured, the country in question was the Philippines, had been procured by bribing the then president Marcos of the Philippines. And that as a consequence, the arbitration clause contained within that contract was, like the underlying contract, vitiated by the corruption, null and void because of the corruption. The U.S. court rejected that argument on very much the same grounds that the UK court did, namely that one requires fraud or corruption going specifically to the agreement to arbitrate. There can be cases where there is a so-called doubly relevant fact, a fact which goes to both the existence and validity of the underlying contract and simultaneously of the arbitration agreement. The classic example that is given is a lack of consent, lack of any consent. One party claims that the parties concluded a contract. The other party says, I never concluded any contract with you ever of any type. I never even heard of you. I didn't sign the underlying contract. I never saw the terms of the underlying contract. I never agreed to those terms. And those claims simultaneously go to the validity and existence of the arbitration agreement. The counterparty says, not just, I didn't agree to the underlying contract. It says, I didn't agree to any contract. Didn't sign this contract, didn't consent in any fashion to this or any other contract with you. And in those circumstances, one has a doubly relevant fact, a fact that goes to the existence of both the underlying contract and to the arbitration agreement. It's not that the arbitration agreement is non-existent because the underlying contract is non-existent. Instead, it is the arbitration agreement is non-existent for the same reasons independently that the underlying contract is non-existent. And the same rationale applies to an arbitration agreement in our corruption example. Corruption is used in the case of the Philippines example to obtain a more favorable underlying contract, to obtain a concession to land that one could explore or to build a nuclear power plant on commercial terms that are more favorable than ought to have been agreed to in the free market, free negotiating situation. But there's no suggestion in those cases that one bribed the government in order to obtain an arbitration agreement. And the same was true in the Fiona Trust case. The ships were leased at a below market rate, but there was no suggestion that somebody bribed a counterparty in order to obtain just the type of arbitration agreement that exists in almost every ship charter arrangement. And in those cases, therefore, you don't have a doubly relevant fact. You have a fact that's relevant to only one of the two contracts, not to both of them. And as a consequence, I think one needs to look at what the corruption charge is, what the allegation of corruption is. Is it an allegation that the terms of the underlying contract, or perhaps even the existence of the underlying contract, were procured by corruption without any hanky-panky with respect to the dispute resolution provision? Or, and this is a little hard to imagine because parties don't usually do this, but did somebody go out and pay a bribe in order to get an international arbitration agreement? That, as I say, isn't something that ordinarily happens, but it wasn't, that certainly wasn't the circumstance in either Fiona Trust or the Philippines versus Westinghouse case. In each situation where one had a relatively standard international arbitration agreement, not something that was procured by fraud. I hope that's responsive to the question. And I think with that, I'm almost to the end of the presentation. In addition to arbitral seat, I mentioned the things that one needs to pay attention to are constitution of the tribunal, number one, language of the arbitration, and finally, number three, choice of law clause. Language of the arbitration can be particularly important. If you're in a multilingual or bilingual continent like Africa, it can be especially important. Is the arbitration in English? Is it in French? Is it in Arabic? Is it in some other language? If you want certainty in advance, you ought to agree on a provision that, and again, it's quite simple to draft, that says something like the language of the arbitration shall be French, or whatever language one wishes to include. If you don't do that, then institutional rules, if you agree to institutional arbitration or national law in other cases, provides a default mechanism. Typically, the arbitral tribunal can select the language for you, or in order to, and this is something you would ordinarily want to avoid, have a bilingual arbitration. You want to avoid it because it is significantly more expensive and time consuming. And finally, method of constitution of the arbitral tribunal. If you agree to institutional arbitration, and this is one of the advantages of that type of arbitration, the institutional rules will have a default mechanism for selecting the arbitral tribunal. If you don't, then national law will supply that. You ought, in almost all cases, though, to have a tailor-made, a bespoke mechanism for selecting the arbitral tribunal, unless you've agreed to institutional rules where its method of constitution is almost always reliable and something you can safely incorporate into your arbitration agreement. I said finally, because that concludes our discussion of the terms of international arbitration agreements. I left out deliberately choice of law, which isn't technically part of the arbitration agreement. The choice of law provision, a little bit like the arbitration agreement, is parasitical to the underlying contract. The choice of the substantive law is not part of the arbitration agreement, even though it may appear in the same provision in the same article. Conceptually, it is a separate agreement as well. Choice of law clause selects the law governing the party's underlying contract, not necessarily the arbitration agreement. And it is important in almost all cases in order to provide certainty, predictability to the party's commercial relationship. It raises questions such as scope and the like that we simply don't have time to address today. You can have the choice of law provision specifically for the arbitration agreement. This arbitration agreement shall be subject to the laws of X, although it's ordinarily not done, with the increasing tendency of some courts, I think in particular of the UK courts, and to some extent Singaporean courts, to conclude that ordinary choice of law clauses, general choice of law clauses in the underlying contract also apply to the arbitration agreement. I think practitioners are increasingly considering the possibility of incorporating in their arbitration agreement the choice of law clause just for that agreement, the arbitration agreement, distinct from the choice of law clause in the underlying contract. But with that, we've had a whirlwind introduction or tour through the world of international arbitration agreements. I've left out many things, trust me, but hopefully that provides a useful laundry list and summary of the principal issues that can arise. I'm of course happy to either elaborate on the corruption question we discussed previously or to come back and answer additional questions, whatever would be best for you.
Professor Bourne, we do have an additional question, again, in the context of the Bismuth problem.
Okay.
Yes, It's about the possibility of invoking your own internal restrictions, constitutional restrictions, as to the ability to enter an arbitration agreement. And to give a little bit of a background, respondent in the present year's case is a state-owned enterprise, and therefore it has invoked its constitutional law because they need an extra authorization from the parliament to enter into the arbitration agreement, which it turns out they did not get the authorization.
So this is again in a sense a recurrent issue. There are countries that have those sorts of restrictions. Iran is a leading example. The United States has a similar type of a restriction, at least in some contexts. There's a classic U.S. case that involved the commander of a military vessel, which went aground and required sort of rescue by a commercial tugboat or rescue vessel. And the captain of the military vessel signed a salvage contract, which is customary in these types of situations, in order to have the local tugboat rescue the vessel from the sandbar or wherever it was stranded. And subsequently, there was a dispute about the validity of the arbitration agreement because captains of vessels, although charged with captaining the vessel, didn't have the authority to commit the United States to arbitration. And there was a dispute about that. The US court, in my view, quite wrongly, held that the arbitration agreement was invalid because it lacked the approval of the Attorney General of the United States, who was the appropriate person to commit the United States to arbitration. And as I mentioned, a little bit oddly, Iran has a similar type of requirement. Most courts and most tribunals certainly have rejected a state and state-owned entity's effort to rely on its own internal constitutional provisions. They've done so on a variety of theories. One theory, particularly where states are involved, is that a state can't invoke its own domestic law as an excuse for failing to perform its international obligations, the obligation to arbitrate being an international obligation, the domestic law approval being self-evidently domestic law. Perhaps that excuse works in a domestic legal system, but it doesn't work on an international plane. The Vienna Convention on the Law of Treaties has provisions that address this, and perhaps the Mooties are already exploring the intricacies of those. They limit quite significantly the ability of a state to rely on its own domestic constitutional or other requirements for consent. In some cases, issues of good faith arise if a state-owned entity concludes an agreement and then subsequently seeks to resile from that agreement on the basis of its own legal system. One has to raise questions about the good faith in concluding the contract in the first place, which in turn gives rise to issues of estoppel. If the foreign state entity either knew of or should have known of its own domestic legal requirement, should it be permitted subsequently to rely on that requirement to invalidate a contract with a third party? I hope that's responsive. I can see this will be an important issue. There are cases that have addressed this, and there's a section in my treatise that no doubt people are working their way through as we speak.
Yes, a follow-up question on this issue. The authorization itself, do you, as Professor Gary Bourne, see it as an additional formal requirement, or is it a substantive requirement to enter into an arbitration agreement?
I would regard it as a substantive requirement. Just as an initial thought, I'd want to think further about it, but it doesn't seem to me to be, it seems to me difficult to characterize it as a formal requirement. Formal requirements are things like The arbitration agreement has to be in writing. The arbitration agreement has to be signed or have two signatures in some people's view, or contained in an exchange of letters. The approval by Parliament or the Attorney General or somebody else it's difficult to characterize it as a part, much less a formal part of the arbitration agreement. It's rather a step in valid consent to the agreement to arbitrate. I would have thought. I would have thought that if you sort of think about the issues that I raised, things like estoppel, things like the international law principle that a state can't rely on its own domestic law as an excuse for failure to perform its international obligations. Those aren't formal rules of form, they're rules of substance. So I would, at least at a first thought, I would be hesitant to say it's an issue of form. I can see the notion that characterizing it as an issue of form brings it into the New York Convention's uniform rules and would, by virtue of the exclusive character of the formal requirements of the New York Convention, prevent the addition of a further national law requirement. I can see how that might be attractive for some parties, but I don't think it's easy to characterize it as a question of form.
I would have an additional question. I'm probably taking a step back into the corruption issue.
Okay.
Yes, and I just would like to have your view on one point. You had mentioned basically what the parties would have to substantiate, or to what extent the parties would have to substantiate these claims of corruption. And my question is, with respect to determining the validity of an arbitration agreement, how far would a tribunal have to basically investigate claims related to the substance, meaning that the main contract is void ab initio due to corruption? And so I just wanted to have your insight on this issue with respect to arbitration agreement. Is it just going to be a prima facie sort of analysis of the different facts, or is it going to be a deep analysis of the different claims of the parties?
So I think there are a couple of things. One, I would be hesitant, quite hesitant, to say that the tribunal had an independent duty, if neither party raised it, to investigate, to raise and investigate claims of corruption. I think a state would have the ability to waive objections to the validity of the agreement to arbitrate, even if such valid objections might potentially have existed. I could see an argument that the tribunal has an independent duty to consider corruption issues with respect to the underlying contract as a matter of mandatory public policy of some sort. But I think with respect to the arbitration agreement, a state could validly accept the agreement to arbitrate. Would be my initial take. I suppose that a tribunal might have an obligation to investigate, the unusual but specific possibility that the arbitration agreement itself was procured by corruption. As I mentioned previously, I think that's a very unlikely scenario, and therefore I don't think tribunals ordinarily would have any obligation to look into that if the parties haven't raised it. I can imagine some sort of argument based on international mandatory public policy against corruption that a tribunal would have to at least consider whether the arbitration agreement had been procured by corruption. But I think that is, as I mentioned, I think that is just as a commercial matter, highly unlikely. Parties just don't bribe people, countries to get arbitration agreements. If one party raises corruption, then I think a tribunal can't simply make a prima facie determination one way or the other. The arbitral tribunal has to decide that claim, has to take evidence and decide that claim the way that it would address other substantive issues in the arbitration. If one party says, for example, that it never consented to the arbitration agreement, or alternatively, that the parties separately agreed to terminate the arbitration agreement itself specifically, tribunal wouldn't make a prima facie determination of those issues. It would decide those issues on a balance of probabilities or whatever higher standard might exist. The tribunal would have to do that in the same way that it addresses other issues in the arbitration. Were the goods defective? Were they delivered on time? And so forth, I would think.
Thank you very much, Professor, for your insight on this. I think that we are slowly reaching the end of the hour that we had scheduled for your presentation today. And I think that you also managed to answer all of the questions which have been submitted in the chat. So we thank you also for that. And yeah, so I think that all that's left for me to do is to thank you once again, Professor Born, for your interesting and especially helpful lecture on arbitration agreements today. And I'm sure that the students and coaches who joined us today have learned a lot and that they'll implement all of this new knowledge in their arguments in this year's Wismut problem, and also in their future arbitration careers for those who want to pursue one. And yeah, and I'd like to also thank once more Rada and African the Moot's Educational Committee for creating this opportunity for the students to get insight on arbitration agreements from one of the most reputable, if not the most reputable practitioner out there. And I also would like to inform everyone that a recording of today's session will be made available on African the Moot's YouTube channel. The link of the recording will be provided in the following days. And also Professor Born has kindly suggested to make the presentation of today's lecture available to us subsequently. So we will also make those available as soon as possible. And yeah, so I will also leave the last words to Rada if she wants to add anything, and also to Professor Born. But on my side, I just wanted to thank you once again for taking your Saturday, for being here with us, and for Professor Born for taking also time on his Saturday for being here with us, and wish everybody a great remainder of the weekend.
Thank you, Sheila. I believe Sheila said it all. I would like again to thank Professor Gary Born for the lecture, and I would like to thank all the participants for tuning in today. And that's it.
Thank you, Rada and Sheila, and thank everybody else. I also neglected to thank my colleagues at WilmerHale who contributed very much to making this lecture possible. And enjoy the rest of your weekend. It was a pleasure to be with you again, and I'm sure I'll see you in future years. Thank you.
Thank you.
Bye. Thank you.